Hello, this is the first of a number of videos in which we're going to look at the General Data Protection Regulation, otherwise known as the GDPR. Data protection issues were first addressed in the 1980s. And back in the 1980s, the two big problems were issues with credit rating agencies and junk mail. It's hard to imagine now that junk mail was ever really that big a problem, given that postage is so expensive. But this was a big problem back then. And the problem with credit rating agencies persists even today. And the problem there was that people were being negatively impacted by errors in the data stored by credit rating agencies. So if you took out a loan and there was a mistake with repayment, or the banks mistakenly notified some issue, that could have serious consequences for a person's credit rating and cause problems for them. So a number of issues were identified with credit ratings, and there was legislation introduced to try and address some of those problems. So one of the problems with credit rating agencies was that it wasn't known, for example, how many there were. And so a solution to that problem was to make people who store information about individuals register so they could be identified. It wasn't known what information they held. So we had to require such companies to register what kind of information was being held, and also to allow individuals to see and to know what was being held. Mistakes happened from time to time, and so there was a requirement to allow individuals to see not only what information was being held about them, but also to append notes to that information where individuals believed that there was an error or a mistake. So sometimes information was misused and wasn't really used in proper ways. So a solution there was to restrict the uses of such information. It also happened that the amount of information that was being stored was excessive, and the kinds of information that were being stored on individuals weren't appropriate. So restrictions were placed on the type of data stored and the time for which it was stored. So these problems and then the proposed solutions led ultimately to legislation. So in Ireland, for example, we had the Data Protection Act of 1988. And in hindsight, this was quite progressive. I suppose Ireland was a bit of ahead of the curve there. And later, the EU introduced the Data Protection Directive. But by the time this directive was introduced, and by the time member states in the EU were required to legislate for data protection, Ireland was already pretty much doing that. It's worth taking a little bit of time to explain the difference between a directive and a regulation. So an EU directive is an instruction to member states to achieve a particular objective. But it doesn't specify in detail how that should be done. It allows member states to figure out that for themselves. And this approach makes sense because different member states of the EU have very different legal systems. Ireland and the UK, for example, had very different legal systems from France and Germany. And so this approach allowed each member state to integrate the objectives of EU law into their own existing legislative framework. For example, the Directive 2060, and this includes a requirement to charge for water, but it doesn't go into details. So a directive is a requirement from the EU, an instruction by the EU to member states to achieve some objective. That objective then is implemented by individual member states. So the French Parliament, for example, might pass a law that gives effect to the directive. The Irish Parliament, the Dáil, might pass a law that would give effect to the directive, and the Swedish Parliament would also pass a law that would provide for what was required by the directive. Now that's very different then from a regulation. A regulation, in contrast, is an EU law that is self-executing. It doesn't require any actions on the part of individual member states. The law applies across all of the EU, and all member states are required to abide by it, and all EU citizens and businesses are required to abide by the law, and any protections that the law provides EU citizens apply directly, and they can exercise those rights immediately. So it doesn't require an implementing law by the national parliaments. And so that's quite a difference. So the Data Protection Directive came into force in 1995, and it probably even took a few years to develop before that. So in the 21st century, it became very clear that that law was a bit dated. Technology had moved on a lot since then. If we consider that the directive came into force in 1995, it's worth looking here at the different technologies that came to be used after that. So it wasn't actually until 1998 that we got the first Apple iMac. And the iMac introduced a lot of individuals to the internet. A lot of people were not online before the iMac. Google only came about in 1998. So we have a law there on data protection that predates Google. In 1999, this Nokia 3210 was all the rage. That's how old the directive is. The Apple iPod came out in 2001, and we only got Facebook in 2004. So the data protection law predated Facebook by almost a decade, and the first iPhone was sold over a decade later. So in the 2010s, it became clear that the data protection regime that was in place was not sufficient to account for all of the new technologies that had arrived since it came into force. So the General Data Protection Regulation, or GDPR, was introduced, and it attempts to address the changes that had taken place since 1995. But also it tried to provide a framework for data protection into the future. So it was also quite forward-looking, recognising that technology advances quite quickly and that the law doesn't. The GDPR was framed in such a way that made it a little bit flexible and a little bit adaptable so that it could maybe accommodate unforeseen developments in technology. So the GDPR repealed the Data Protection Directive and replaced it. In practice, though, it built on the protections that were provided by the Data Protection Directive. And a lot of what we learned and a lot of the principles that were developed for the Data Protection Directive apply also to the GDPR. So it's more of an upgrade rather than an entire substitution, although legally it's a whole separate thing. At this point, there isn't much to be gained by considering the directive in detail, but most of the principles that were developed under the directive still apply under the GDPR. Here are some of the main data protection principles that were developed under the directive, and it's worth taking a look at these. So people who gathered information about individuals were required to obtain and process that information fairly. They had to keep it only for one or more specified, explicit and lawful purposes. So you had to say why you were collecting the data, and you could only collect it and use it for that purpose. They had to use and disclose the data only in ways that were compatible with those purposes, and they had to keep it safe and secure. People who stored data on individuals were also required to keep it accurate, and being accurate meant being complete and up to date. So if, for example, there was a flag on someone's credit rating that they hadn't paid something and that information was inaccurate because it was incomplete, they were required to correct that. They had to ensure that it was adequate, relevant and not excessive. So you couldn't keep more information than was necessary for that purpose. They had to retain it for no longer than was necessary for that purpose. So if you had a good reason for collecting information, it may be that there was no good reason for you hanging on to it for 20 years. And very importantly, they had to give a copy of that information to the individual if they requested it. So these principles came out of the Data Protection Directive, but they still apply under the new regime that was brought about by the GDPR. One of the key data protection concepts that was developed for the directive was the idea of the data controller, the data subject, and the data processor. So a data processor processes data on data subjects on behalf of a data controller. So you could have a situation, for example, where Tesco, a supermarket, is the data controller, and Dan Murphy, a customer of Tesco, is the data subject, and then some data processing company somewhere, maybe, Mega Data Corp or something, is processing information on behalf of the data controller. So we have those three distinct actors in the system: the data controller, the data processor, and the data subject. The GDPR is available in all of the official languages of the EU. Obviously, we're going to be looking at the English language text. If you speak another language other than English, it may be worth familiarizing yourself with the vocabulary in the other languages, just to get a handle on the specific terms that are used, because the terminology can be quite specific and in some cases quite unusual. The GDPR is broken up into different chapters, and we're going to look at those in turn. The first chapter has just general provisions, and that's quite vague and not very specific, but it does have some useful definitions. Chapter 2 is perhaps the most important chapter. It sets out the various principles. It sets out what makes processing lawful. It elaborates on the conditions for consent, and it also specifies certain categories of data that require special attention. Chapter 3 specifies the rights of the data subject, and those rights are extensive. Chapter 4 then sets out the obligations of both the controller and the processor. And data controllers and data processors have quite a lot of obligations to meet. Quite a lot of attention is paid to the transfer of data outside of the EU, and that's covered in Chapter 5. And Chapter 6 deals with the enforcement and supervision of the GDPR. We're not going to look at that so much. And Chapter 7 deals with the remedies that are available to data subjects, the various issues around liability and penalties. So in summary then, the GDPR replaces the Data Protection Directive. The directive came into force in 1995, and a lot of new technological developments came after that time. The GDPR attempts to account not only for those new developments, but also for the unforeseen developments in the future. It's worth noting that, unlike the directive, which required implementation by individual member states, a regulation is an EU law that applies directly throughout all of the Union. And although the GDPR replaces the directive, in practice, it just builds on it. So many of the principles that were developed for the Data Protection Directive also apply to our understanding of the general data protection regulation. So in the next few videos, we're going to look then in detail at the different provisions in the different chapters of the GDPR.